So, Larry Sala?
So, great exchange. And if you haven't already looked at Mike and John McGinnis's articles in the Northwestern Law Review that contains many of the ideas that Mike talked about here today, I really would commend it to you. I just have two comments. One is that this interpretation construction distinction is a very old distinction in common law traditions. This is not, there's some tendency as the distinction has been invoked in constitutional theory to say something like, well, Keith Whittington came up with this in the 1990s. And that's just not true. If you look at writings on constitutional law, contract law, the law of trusts and wills, from at least from the early 19th century, you clearly see a recognition of this fundamental and analytic difference between determining the linguistic meaning or semantic content of a legal text on the one hand, that's one activity, and the activity of translating that linguistic meaning into legal doctrines. So in contracts cases, we got to figure out what the party said, what the linguistic meaning of the contract is, and then we've got to decide what legal effect to give it. Right? In constitutional law, the same distinction is observed at least as early as the 19th century. I haven't done any more historical research than to get me to that point. And the second thing I want to say is that it seems to me that there is a potential and a very important misunderstanding going on here, at least in terms of what my position is. And I think in terms of the general understanding of the interpretation-construction distinction and the role of normativity. So the distinction is this. When we're trying to determine linguistic meaning, the work has to be done by linguistic facts. It's not done by normative argument. The meaning of the term legislative power or freedom of speech or Senate or whatever the term is, the meaning of the terms in the Constitution is fixed by linguistic facts at the time of the framing. Normativity comes in construction, not in the way that Mike suggests. It's not that you have to interpret, that you have to import a normative theory in order to do the process of construction. If you're a libertarian, you construe a libertarian way. If you're a social conservative way. That's not the view at all. It's that whatever principles of construction you adopt, you have to give some reason why we should adopt those principles. Now, that's exactly what Michael did. Michael argued that we should adopt original methods in order to get constraint, right? That argument is a normative argument. Now, he had another argument, too, which I think is very interesting.
Larry, can we...
But I will leave that for another exchange.
Mike, do you want to respond?
Yeah.
We only have about 5 minutes. We have to stop at 1:45. So.
Okay, so let me say two things. First of all, Larry's quite right. His version, I mean, he has a different version of construction than Randy does, and I'm not quite sure, I don't think actually Larry has come out and written up how he would do construction. I was actually, so what I said only references in part to what Larry was doing. I was focusing on Randy's discussion of construction in his book, which I think is fair to say does reference normative considerations, reflected somewhat in his remarks, and I would just say take a look. I think he says that pretty clearly. So that's for it. There could be other versions of construction that do something different. Different arguments would apply. I would still hold to the view that I actually think these things are covered. They're close cases, but they're still part of the meaning. But that's a separate question. In terms of Larry also mentions that construction is a very old idea. And I guess I would want to suggest for constructionists, and maybe this is a kind of a friendly suggestion, if one thinks that this is what the framers were doing, an article really needs to be written going through the original materials, showing, here's construction, here's where James Madison is doing it. Here's where Marshall is doing it. See, they don't use the terms, but that's what they're doing. I actually just don't see it. What I see is close questions resolved as I've suggested. But I would say for really make a convincing case of construction, that kind of work would be useful.
Time for one more?
It sounded to me as if the area of disagreement is extremely narrow. Let me just see if I can hone in. So let's leave ambiguity aside. I agree that's an interpretive matter. In terms of vagueness, in terms of terms that are vague, a lot of vagueness can be eliminated by looking at the authors and their purposes and the like. So within the range in which a term might be vague, we can eliminate a fair portion of that range. That leaves us with the area of ineliminable vagueness. And I would have thought in a case in dealing with the Constitution where there's ineliminable vagueness, one can't say of whatever law is under question that it's unconstitutional. That if it's in that area, one has no warrant for deeming it unconstitutional. Now, that's like a default in terms of what the legal system is like. The normative side, I think, comes in a different area, which I would call implementation of meaning, which is the doctrines by which you implement a meaning, which might not be vague at all, might be quite clear, but there's still a step between that meaning and applying it in cases. Mitch Berman has something, even the burden of proof of whether the constitutional rule has been violated requires a construction of an implementation system, and that's going to be normative. And I think it's a particularly interesting question where the norms for that are supposed to come from. But I think that's a different question from the vagueness question, which I think is usually answered in constitutional law by, if you can't say it's unconstitutional, then that ends that question.
This will be the last, I assume, round of questions.
We'll see.
I'm not sure how much I disagree with anything that Larry just said. The principal time in which I use invoke the idea of construction in my book is when I'm debating the presumption of constitutionality versus the presumption of liberty. And then I argue that we choose amongst these constructions for normative reasons. So yes, normativity does enter into in the choice of these constructions. I make that claim. But I do think it's a choice of constructions, and Larry's picked his. I don't think that you can read that construction off the text. And nor do I necessarily think that you can, read it off the historical record either, but that's another matter. So let me just say that. I only invoke normative considerations in a very limited context in my book. But I just want to emphasize what I started with. Don't throw out the baby with the bathwater. I want to talk about the takeaway from this debate. Do not take away from this debate that if you don't like judges doing construction by means of importing their normative theories, which is how Mike characterizes my approach to construction. If you don't like that, that doesn't mean you repudiate or you need repudiate the distinction between interpretation and construction. It means you don't like that theory of construction. And so just keep it clear in your mind what you like and what you don't like, and that there's nothing particularly threatening about distinguishing between interpretation and construction as long as you're willing to defend your views of construction, like Mike is and like I think Larry is. But there is something wrong and threatening if you ignore the difference between these two activities.
Yeah, I guess maybe in the end we just don't agree. because what Randy just sort of came away with was to sort of take the situations where there's ambiguity or vagueness, or just let's just call it vagueness, and say that, well, that's a construction, and original methods is a version of doing the construction. And I think that's just that's Randy's position on it. But there's an alternative view which basically says people speak against a context of interpretive rules. And sometimes those interpretive rules render and the original meanings of the words render their meaning clear. Sometimes it's close. But just because it's close doesn't mean there's nothing there. This doesn't mean that we're in a non-meaning zone. We're in a difficult question zone. But if the evidence is stronger for one interpretation, then that is the better interpretation, not for construction reasons, but for meaning reasons. And so that would be the alternative take that I have on this matter.
Thank you very much.